Welcome to Canadian Justice. I'm K.R. Davidson, and today we're talking about what has been termed as one of the most significant challenges in Canada's legal history. On September 10th, British Columbia Supreme Court ruled against a privatized healthcare advocate, Cambie Surgeries Corporation, and other plaintiffs, and the case is now being appealed to the BC Court of Appeal. The matter before the trial spanned 10 years, with the trial taking 4 years to complete and the court issuing a staggering 880-page decision. At the heart of the case was a constitutional challenge to British Columbia's public health care model, with Cambie and other plaintiffs arguing that the public health care model prevents patients from accessing private, medically necessary health care, which ultimately violates their right to life, liberty, and security of person. Proponents of the public health care model argued that a private model would not improve wait times and would compromise Canada's healthcare system. With me today to provide a greater overview of the case is Dr. Brian Day, the president and CEO of Cambie Surgeries Corporation, who is also the past president of Canada Medical Association. So thanks for being on the show with us, Dr. Day. You're at the heart of this matter before the courts. Can you give the audience an understanding of why your corporation brought this forward and some of the issues at the center of this claim that you brought?
Well, this claim began in January of 2009. That's coming up to 12 years ago. And it was initiated because clinics that had been treating patients for many years and they had operated since the Chowley decision in 2000, which came a bit later, were threatened with closure. And one of the things I think people often forget is that there were originally 6 patient plaintiffs as well.
Yes.
3 of those being children and 3 were adult cancer patients. Sadly, one of the cancer patients died before the case, before the action could begin, and another died during the course of the action. And people often try to portray this as an institutional challenge, but the majority of the plaintiffs were patients. And these are patients who are suffering on wait lists. And the Chowley decision in 2005, which was under the Quebec Charter, which is persuasive but not binding necessarily. We don't know that yet because it hasn't gone back to the Supreme Court of Canada on other provinces. We were told that it was binding, and we were operating we've been operating for over 25 years. The fact is, the patients, due to rationing, were not getting access to healthcare. In BC, in our trial, we had evidence that 41% of British Columbians on wait list had waited past the maximum acceptable time that the BC government itself had said they should wait, and beyond which there was a risk of significant harm. So we launched that suit. This has been going through the courts for a very long time. We're now going to the appeal court level, and the case the appeal court in British Columbia will take place in June of 2021. But it is a case about patient rights. In 2005, the Supreme Court of Canada said that patients in Canada were suffering and dying on wait lists. And that's still the case. And we showed that in the evidence in British Columbia that it's still the case. And that was a violation of their rights under the Charter.
So basically your clinic would be able to offer surgeries or health care to patients that wish to be able to not have to wait for care that would otherwise be offered by the public health care system?
Yeah, so our case is basically, if a government promises you healthcare in a timely manner, which it does, and then fails to provide that care, we cannot be the only country on earth which denies you the right to look after your own body and save your own healthcare from deterioration. So one of the things that came out in evidence, for instance, is in just one that Canada is, and this was a government expert from Harvard who said this, we are the only country on earth in which it's illegal to buy private health insurance for medically necessary procedures.
Dr. Day, it's a great point, and I thank you so much for coming on and just giving us an overview of this part with us. Welcome back to Canadian Justice. We're here today talking about a case that was before the BC Supreme Court on privatized healthcare in Canada. And with me to discuss the case that was before the court is Joanna Barron, who's the Executive Director of the Canadian Constitution Foundation, which served as a supporter for one of the plaintiffs, Cambie Surgeries Corporation, and Pauline Worsfold, the chair of the Canadian Health Corporation. So thanks so much for being with us today. Ms. Barron, if you can give us an understanding of your client's perspective here. Specifically, I know the Canadian Constitution Foundation served as a supporter, and I guess client might not be the right word, but you served as a supporter for the Cambie Corporation. Can you please tell us what that means and what Cambie's position was before the BC Supreme Court?
Certainly, and thank you for having me on. So the Canadian Constitution Foundation is a legal charity. Our mission is to protect and defend Canadian constitutional liberties. And we believe that this litigation, the litigation of Cambie, is litigation that will affect the rights of every Canadian. So we provided assistance with fundraising as well as with communications. You're right that they're not our client, but we are supporting the litigation. And essentially the case is quite simple. In 2005, the Supreme Court of Canada issued a ruling in a case called Chaouli, where the former Chief Justice stated very clearly, access to a waiting list is not access to healthcare. And the problem of excessive, beyond medically acceptable wait times has persisted in Canada, particularly in British Columbia. And we believe that the government cannot both fail to meet accepted targets for waiting lists and at the same time prevent individuals from taking their health into their own hands. This is a violation of Section 7's guarantee of life, liberty, and security of the person. And so that's why we are supporting this litigation, and I believe that it's very important litigation.
So, Ms. Worsfold, your organization has created a campaign of awareness advocating for the model that's currently in place for the public health to continue and to not permit privatized healthcare. Can you give an understanding to our viewers of why you continue to advocate in this respect?
Certainly. The Canadian Health Coalition has been around for about 40 years, and we believe in protecting and expanding Medicare in Canada for everybody who lives here, not just the rich who can pay. So the point about having clinics privately run and run for profit really flies in the face of Canadian values. We shouldn't have to purchase healthcare, and being able to purchase healthcare is limits the number of people that can actually access healthcare at a private for-profit clinic.
So, Ms. Barron, ultimately the court, Justice Steeves in this matter, determined that the public health care system should remain intact and the privatized health care as presented by the plaintiffs in this matter should not be permitted. The court, it's my understanding that the plaintiffs have appealed this decision and it's going before the BC Court of Appeal now?
Yes, correct. And I would just add that we share Ms. Worsfold's goal and everybody's goal in this country to continue to expand and improve on the Medicare system. We believe that it should be strengthened. However, the evidence suggests there have been independent private clinics operating in BC since 1996, and there's been no deterioration in access of care. In fact, there have been overall more surgeries conducted, freeing up space for people in the public system for those who choose to pay and access care sooner. But to get to the legal analysis and justice in the trial judge's decision, he found that there was not that the violation of life, liberty, and security of the person was in accordance with the principles of fundamental justice. I'm using legal language here. And in order to find that, he found that the limitations on accessing private care were necessary to safeguard the integrity of the Medicare system. And this is in spite of, again, evidence right there in BC that such an outcome never came to pass. And I would also add that when we talk about the Charter, we're talking about rights of individuals against government action. And so the proper focus should be on the harm suffered by patients. One of our patient plaintiffs was 8 years old when he was diagnosed with a spinal curvature, and it progressed to a point where it would cause permanent damage and he's permanently paralyzed. So that type of harm has to be our focus in this analysis.
So we're going to go to some commercial messages, but when we come back, let's talk about some of the wait times, which I think is really at the heart of this issue. Welcome back to Canadian Justice. We're here with our panel. We're talking about a case before the BC Supreme Court addressing privatized healthcare in Canada. Ms. Worsfeld, it's my understanding that really at the core of this case, the judge was looking at the question of wait times, and specifically wait times that had exceeded the maximum that would be prescribed within the province. It's your organization's position that the public health care system can meet this, but in this case, they're talking about patients that have exceeded those maximum wait times. How do you respond in this respect?
Well, we support Justice John Steed's decisions for sure, and we were monitoring the entire case all the way along in coordination with the BC Health Coalition and Canadian Doctors for Medicare, who also support the public health care system here in Canada. So as far as wait times, the sickest go to the head of the line, not the richest in this country. So if you are in your 70s and you need a hip replacement, but yet you can play 3 rounds of golf a week, you're not going to be at the top of the list. Who will be at the top of the list is a frail person who fell and broke their hip, and they will get the hip surgery before the golfer. So the ability to access healthcare in Canada should not be based on your pocketbook. It should be based on need.
But specifically in this case, I believe that it was referenced patients that have exceeded the maximum wait time prescribed by the province. And so what is your position when there's patients that are not being attended to within that timeline that's set by a provincial public health guideline?
If the patient is suffering, they need to go to the head of the line. They shouldn't have to go and pay for private, for-profit clinic services. If the patient, being a registered nurse for almost 40 years, their patients are more and more complex every day. And so the ability to wait if you are ill, that's just not on. You should automatically go to the top of the list. There are public solutions within the public healthcare system. And I have a great case here in Alberta that I could share with you.
Yeah, and I'm going to go over to that in a minute. I just want to pose a question to you, Ms. Barron. So if we are taking a look at solutions to the wait time problem, and what was before the court was issues where patients were in a place where they had exceeded the maximum wait times prescribed by a province, is there a risk that only people that have the requisite funds would be able to receive that health care, and that in some way that might degrade the public health care system?
KR, the reality is that we know that wealthy Canadians already seek private care by leaving the country. There are at least 300,000 Canadians a year that leave the country to seek care. And we know that these waiting lists have persisted and have worsened over time. Essentially, the disagreement that we're having is that we don't believe that the right to suffer equally is a moral or legally compelling justification for restricting individual rights. And I'm very heartened to hear that Ms. Warfield believes that if you're sick and you badly need treatment, you should not be able to wait. But unfortunately, we know the reality is that this problem persists. And I have to mention this, that this problem has just become multiplied in the current pandemic. Health Minister Adrian Dix in BC has said that the province is facing a backlog now of up to 2 years. And indeed, he has said that part of how the province is going to resolve that backlog is by working with private clinics. So we need to be pragmatic, and we need to look at the facts on the ground and the suffering that is happening and be pragmatic. We need to look at the fact that Canada routinely falls to the bottom of the list in ranking with our OECD allies, all of which I would mention, besides Canada, have a private system as well.
And I think in those instances that you're referring to, that there's a hybrid system of a public privatized model, or in some of the references, are you just seeing a completely privatized model? And sorry, we've just got a few seconds.
So Canada and the US are both exceptional in that the US is the only OECD country that does not have a robust public system, and Canada, the only country that does not have a private alternative. So when you look at countries like Australia, New Zealand,
I'm going to let you pick
France,
up the rest of
and
those
UK.
comments after these messages. Welcome back to Canadian Justice. We're here with our panel talking about a case before the BC Supreme Court, talking about privatized health care. Sorry, Ms. Barron, I just had to cut you off before the commercial message. You were talking about whether the other OECD countries have privatized health care, or whether there's a hybrid system between public and private health care.
Yeah, so there are many options. Canada, as I say, is the only country that goes as far as to ban all forms of private pay insurance. I think one interesting model is the model in New Zealand, where you're guaranteed treatment within 4 months, public treatment. And if the government can't meet that target, then they will reimburse you for seeking private treatment. Equally, if you don't want to wait 4 months, you can go into the private treatment directly at your own cost. So there are different innovative approaches that we can take.
Interesting. Now, Ms. Worsfold, you were talking in our last segment that there are other models within the public healthcare system to address some of the waiting times. What are some of those that you're referring to?
Well, I'll talk about the hip and knee clinic here in Edmonton. It was an initiative by Dr. Cy Frank, and so people were waiting months for their hip and knee replacements. And they came up with an innovative, in the public system, way to address the wait lists. And what they did was they went to surgeons who might be interested in doing this trial. And they said, in order to participate in this trial, you have to give us your wait list. And so once the wait lists of the surgeons were handed over and they were dealt with in a hub, and surgeons were guaranteed OR time within this hip and knee clinic project, the wait times went from months and months down to 5 weeks. And it's still a successful part of the public health system here in Alberta right now. So it's a success story that could spread across the country for hip and knee replacement.
Yeah, very interesting to have a specialized center for being able to address stuff like that. But Ms. Barron, you mentioned earlier at the heart of this issue is, as much as we have a policy issue before us, Canada is obliged to comply with the Constitution, and in this respect, the Charter rights. So what is the Charter right issue that you're referring to in Section 7 concerning life, liberty, and security?
So the guarantee of life, liberty, and security of the person determines that when governments take action through legislation or through fines, they cannot do so in a way that infringes your rights and your ability to seek your own protection and amelioration of your condition. And I'll just mention that this right has been interpreted by the Supreme Court of Canada in a very strong line of case law that includes the right to seek safe injection sites, the right to hire security if you're a sex worker, the right to seek a physician-assisted suicide. And what all of these cases are getting at is that if you're in a situation where you're in some peril that the government didn't cause, but you're in some peril, the government cannot then take action to prevent you from taking steps to secure your own life, liberty, and security of the person. So, of course, we're not saying that the government caused injuries to people who are seeking a hip and knee replacement, for example, but they cannot at the same time turn around and prevent that individual from taking their health into their own hands.
Thank you so much for both of you coming on our show and giving our viewers a better understanding of this matter. Canada has had a publicly funded healthcare system since the 1960s. While many applaud this system, wait times have often been brought to the forefront of political debates, with some arguing that the system in certain instances is not able to accommodate the needs of Canadians. We heard today from public health care advocates that the solution to Canada's wait time are able to be solved within the public health care system. But we also heard that Canada stands as an outlier globally, being the only country in the world that does not permit any privatized care, and that this is harming Canadians. Former Prime Minister of Barbados, Owen Arthur, stated, "For he who has health has hope, and he who has hope has everything." So what do you think? Should Canadians who are on wait list and who are in critical condition be permitted to pay for privatized treatment? Or does privatized health care threaten the core values of Canada's public health care system and the identity of Canadians? You be the judge. I'm K.R. Davidson. Thanks for watching Canadian Justice, and remember, keep examining and know that you are part of the solution.